A power of attorney is an agreement through which a person appoints an agent to act on his or her behalf within the scope of the authority defined in the agreement. But can a general power of attorney to sell another's property also include the authority to gift that property to another? The Maryland Court of Appeals considered this question in the case of King v. Bankerd. Howard and Virginia Bankerd, husband and wife, owned a home in Maryland as tenants by the entirety. Virginia moved out of the home in 1966 due to marital problems, but 2 years later, Virginia moved back in when Howard traveled west to start a new life. Before leaving, Howard executed a power of attorney in favor of his attorney, Arthur King. In 1975, King sent Howard an updated power of attorney, which Howard executed. The power of attorney stated, quote, "I, Howard Bankerd, hereby make, constitute, and appoint Arthur King, my attorney for me, and in my name, to convey, grant, bargain, and or sell the property on such terms as to him may seem best." Unquote. Further, Howard gave King the general authority to do everything necessary to sell the property. In 1977, Virginia asked King to exercise the power of attorney and transfer Howard's interest in the home to her because she wanted to retire and downsize. King attempted to contact Howard but couldn't find where he lived. Due to the lack of contact, King believed Howard had abandoned his interest in the property or was deceased. Consequently, King conveyed Howard's interest to Virginia by deed for no consideration. Virginia then sold the property to another for over $60,000. Subsequently, Howard sued King in state circuit court for breach of trust and fiduciary duty. Following discovery, both parties moved for summary judgment. The court granted Howard's motion, concluding that King violated his fiduciary relationship. King appealed to the Court of Special Appeals, which affirmed. The Maryland Court of Appeals granted cert.